Hello, sir. Sir, you are mute.
Hello.
Hi. Hello, sir. Very good evening, sir. Before we formally commence today's session, may I respectfully seek the permission of our esteemed speaker, Dr. Akash Gupta, to begin today's proceeding?
Please.
Thank you, sir. A very warm welcome to everyone. On the behalf of Just Corpus, I, Vanna Yadav, extend a warm welcome to our esteemed speaker and all the participants to another insightful session of Arbitration 360, Comparative Study of International Arbitration Law. Today's session focuses on a comparative study of international arbitration law, an area that is central to understanding how different legal frameworks regulate arbitration and how effectively they facilitate the resolution of complex cross-border commercial dispute. We are delighted to have with us Professor Dr. Akash Gupta. He is an associate professor and assistant director at the Center for Alternative Dispute Resolution, Jindal Global Law School, where he teaches arbitration and alternative dispute resolution. The objective of today's session is to provide participants with a comprehensive understanding of international arbitration law through a comparative perspective, highlighting the key similarities and differences between Indian and international arbitration frameworks, their procedural approaches, and their practical implications, the resolution of cross-border commercial dispute. It is now my privilege and honor to introduce our distinguished speaker, Professor Dr. Akash Gupta. Professor Akash Gupta is an associate professor and assistant director at a Center for Alternative Dispute Resolutions in the Global Law School, OP Jindal Global University. He's also visiting faculty at National Law School of India University, Bangalore, where he teaches an advanced course on arbitration relating to the setting aside and enforcement of arbitration award. His teaching and academic work primarily focus on arbitration, mediation, negotiation, and alternative dispute resolution. Professor Gupta has extensive academic and professional experience in the field of ADR at Jindal Global Law School. He teaches postgraduate courses including arbitration law in India, international commercial arbitration, and recognition and enforcement of arbitral award, while also he heading the Center for ADR. He's a member of the Young IAMC Steering Committee and has served as arbitrator and mediator with institutions including CORD, Vivad, Sama, and Resolve 360. He holds a BLLB honors from Tamil Nadu National Law University and an LLM in International Commercial Arbitration Law from Stockholm University, where his master's thesis examined the law governing arbitration agreements from an Indian perspective. He has also undertaken specialized program at the Paris Arbitration Academy and a Hague Academy of International Law, receiving a full scholarship and full sponsorship respectively. In 2026, he completed his PhD in ADR from GD Goenka University. His academic contribution include 10 Scopus indexed publication, along with editorial and advisory role with the leading ADR publication. He has been recognized as the Young ADR Academic of the Year in 2023 and regularly contribute to the development of ADR scholarship and practice through the workshop, judging international competitions such as the Westmoot and Jessup Moot and academic engagement across India. With his combination of academic scholarship, teaching experience, and practical engagement with arbitration and mediation, Professor Gupta brings valuable expertise to the certificate course and will offer participants an informed perspective on contemporary development in ADR. Without taking much more of your valuable time, it is my privilege to invite Dr. Akash to deliver today's session. Sir, thank you for joining us. We are honored to have you with us and look forward to learning from your experience and insight. The virtual floor is now yours.
Thank you
Thank
very
you,
much,
sir.
Vandana. So I just request for the share access. I
Just
have it now. I have it. Perfect. Okay. So first of all, I'd like to thank Advocate Ayush for this opportunity. Just Corpus team. Thank you very much, Vandana, for this very kind introduction. So, Vandana, how much time do I have? Do we have to end at 7 or 7:30?
we can extend, sir.
Okay.
There's no
So
such.
the topic which has been given to me is international arbitration, a comparative study. So in this study, what we are going to do is we are going to look at different jurisdictions: India, Singapore, UK, France, and US. So in the next 50 minutes or 60 minutes, what we are going to do is break down these five jurisdictions where we are going to discuss about what is the legal framework, what are the landmark judgments, and how institutional arbitration operates in that particular jurisdiction. Now, please feel free to stop and ask questions on the chat box, and I'll be answering the questions. And the slides link I have already shared, so you have all the slides with you already. So please let's focus on the discussion instead of writing notes or taking pictures. You already have the slides. So whenever you have a question, you just write on the chat box, and then we'll come back to you. The idea of this is to have a conversation instead of a monologue from Akash side, and then you just listen. Okay, now, first thing first, international legal framework. When we talk about international arbitration, is that international arbitration dependent on a national law, or is it something which depends on an international legal framework? The answer comes from something called New York Convention, which is one of the landmark international laws with respect to international arbitration. Now, what is this international legal document? This provides that the recognition and enforcement of foreign arbitral award, the member states have to make sure that the foreign arbitral awards are recognized in between the different member states. Now, in simple words, what happens? Let's say that the arbitration happens in India and you have to enforce this award outside India, let's say in Singapore. What is the international law document that is being used? That is called New York Convention 1958. Now, this is one of the most successful international conventions because it has 172 contracting states. India is a party to it, Singapore is a party to it. Almost all the big jurisdictions or even smaller jurisdictions are almost a party. So in terms of the total number of countries in United Nations, I think it's around 196 or something. 172 are a contracting state of this particular international convention. So you can understand how successful this doctrine is. Of course, there are issues of reciprocity clause that a country can sign it. For example, India has done, but this is one of the landmark international legal framework on international arbitration. Now, two very important parts of New York Convention. One, that it provides if there exists an arbitration agreement, even though the seat of that particular arbitration is outside your state, still you have a duty to enforce, recognize that arbitration agreement. For example, the seat is India. One of the party goes to Singaporean courts. The Singaporean courts have to say that because the seat is India, there exists an arbitration agreement. We cannot allow you to come to our courts. You have to go back to arbitration. That's something which is point number two on the slide, which is Article 2. Now, the second most important part of New York Convention is Article 5, which is point number 4 on the slide, which provides that if an award comes from outside your territory, which is a foreign arbitral award, you have a duty to enforce unless until one of the grounds triggered, which is more like natural justice is breached or there is an excess of jurisdiction. So the state has a duty to recognize arbitral awards. Now, this is primarily New York Convention 1958. Any questions on this part? NYC. Okay. Now let's go to the next one. There is another law which is called UNCITRAL Model Law on International Commercial Arbitration. Now, think of ancestral model law as a template law. Now, what is a template law? It's more like a draft law prepared for national jurisdictions. If you want to modernize your national domestic arbitration law, you can actually adopt it with whatever minor revision or major revision you wish to have. Now, this was something which came in 85 and it was also amended in 2006. So, Indian law, which is Arbitration and Conciliation Act, is actually an adoption of this. Another example is Singapore International Arbitration Act, that is also an adoption of ancestral model law. Now, there are four major principles which is enshrined under this model law. For example, party autonomy, that parties can choose who are the arbitrators, what rules to follow, what should be the seat. Then there is another principle which is called competence, that it's the arbitral tribunal which gets to decide that whether they have the jurisdiction, whether they have the power. Three is separability, which means that the arbitration agreement has to be is of a separable nature when there is an attack on the validity of the arbitration agreement. Fourth is the limited judicial intervention, which means that the judiciary is not the boss of all of this arbitration system. The judiciary is going to complement and has to follow a limited judicial intervention principle. Now, ancestral model law is more like a template law. The third one is ancestral arbitration rules. Now, what is ancestral arbitration rules? These are majority of the times this is used in ad hoc arbitration when you do not choose an arbitration center. For example, A and B decides to have an arbitration. Without going to an arbitration center, they need to use some rules. Either they make their own rules, or what they can do, they can rely upon something called ancestral arbitration rules. Now, there are some versions which are there under point one. Now, what's the difference in between ancestral model law and arbitration rules? Please pardon this typo in ancestral, it's ancestral. Now, what's the difference in between model law on one side and the arbitration rules? Now, model law is for the national laws. For example, India can adopt, for example, Singapore has adopted. Ancestral arbitration rules are for the parties to choose as a rule which is going to be used for conducting the arbitration. That's the larger difference. Now, for example, you must have heard about the Spy Universe by Yash Raj, or the other universe by Aditya Dhar. There is something called the arbitration universe, what I call it. Now, within this arbitration universe, there are four things because of which arbitration operates. The first layer is treaty, which is more like an international law. Classic example, New York Convention, 1958. Second layer is national law. National law is the national arbitration law. For example, in India, it's Arbitration and Conciliation Act, 1996. The other jurisdictions, we are going to discuss this in the later part of the discussion. Third one is the institutional rules. When I say institution, it's the arbitration centers. For example, in India, we have Mumbai Center for International Arbitration. You have IAMC Hyderabad. So they have their own rules based on which they conduct arbitration. These are institutional arbitration rules. The fourth one are soft laws. Soft law means that it's not going to be binding per se, but the parties can choose to make it to the parties may apply with the consent of both the parties. If both the parties say that we wish to include IBA rules while deciding the procedure of this arbitration, they have all the rights to decide that. So IBA rules is basically International Bar Association rules on taking of evidence. Then you have IBA guidelines on conflict of interest. Then there is ancestral notes on organizing arbitral proceedings. Now, these are essentially to understand what is the international legal framework for arbitration, because unless until we understand that how does arbitration gets the power internationally, it's very difficult for you to understand how international arbitration operates within a national jurisdiction. So first, I laid down the basic of international legal framework. Now we are going to the next level, which is country-specific jurisprudence. Any questions so far? Okay. Now, let's start with the first jurisdiction, that is India. In India, we have the National Arbitration Law, which is Arbitration and Conciliation Act, 1996. Now, if you look at this particular law, this is an adoption of ancestral model law. This has an adoption of ancestral conciliation rules. Also, New York Convention is a part of our Indian law, which is part 2 of the Arbitration Act. Now, what are the different parts within this particular national law? There are 4 parts. First is the domestic arbitration. Domestic arbitration means when the seat is India. That's domestic arbitration. Part 2 is enforcement of certain awards, which are foreign awards, which is in usual terms, it's called foreign arbitration. Now, for this, we have New York Convention. There is also Geneva Convention for the predecessor awards. Part 3 is the conciliation, which provides for conciliation, what kind of disputes are suitable for it, what's the enforceability. Part 4 is the supplementary provisions, which is more like the miscellaneous one. Now, within the Indian framework, there are some sections which actually provides very important keywords. Now, those keywords are very important for you to read. So some of the important ones are right here on this screen, starting with first, international commercial arbitration under section 2, subsection 1, clause F. Now, what is international commercial arbitration? If one of the party is a party which is international, which is situated outside India, which has an international element to it, then it becomes an international commercial arbitration. It may be a chance that both the parties are in India. For example, Sangyong. Sangyong also has a company in India, but Sangyong is a South Korean party, so it has an international element. So Sangyong versus NHAI is not a purely domestic arbitration. It's domestic and ICA, which means domestic because the seat is India. ICA because Sangyong is a South Korean entity. Now, Section 7 provides for what constitutes arbitration agreement, the definition of arbitration agreement. Section 9 provides for court-ordered interim measures. Section 11 provides for appointment of arbitrators. 12 provides for independence and impartiality of the arbitrator. 16, it's the competence principle, which we just talked about from the answer trial model law. 17 provides that the arbitral tribunal can also give you interim measure. Section 20 uses the term place of arbitration, but the meaning of place within the Indian jurisdiction is seat of arbitration, and seat is a very international term. That's why I made seat within the bracket, I wrote place. So please don't get confused with this place as venue. Venue has nothing to do, no effect on the legal part of arbitration. Venue is just a physical or a virtual place where arbitration take place. Seat, wherever the seat is, the national arbitration law of that particular location will be applicable. If I say seat is Singapore, Singapore International Arbitration Act is applicable. If I say seat is Sonipat, it means that the National Arbitration Law of India will be applicable, that is Arbitration and Conciliation Act. Section 34 provides for setting aside of an award, which is also called challenge, annulment, all of this is same. Then section 44 to 50 provides for recognition and enforcement of foreign awards. Now, if we look at the Indian jurisdiction, we see that there has been a trend of moving from court-centric approach towards greater arbitral autonomy, especially with 2015, 2019, and 2021 amendments coming in. Now, it's a bit lesser judicial intervention than before, but still we have a lot of work to do in this regard. Now, there are some cases which are very important for you to understand, starting with the first one, that is Balco versus Caser Aluminium, in which the Indian court said if the arbitration is situated outside India, then part 1 does not apply, which means if you choose a foreign seat, let's say you have chosen Singapore as the seat, Indian Arbitration Act is not applicable, which means that if the foreign arbitration happened in Singapore, you can't take that award in Indian jurisdiction and use Section 34 to set aside the award, which was happening before 2012. Now, all of this was settled through Balco. But before 2012, India was actually setting aside the awards, even if it was a foreign seated award. The next case, the first point on this slide, is TRF and Perkins. Basically, both of these provided for one thing, that unilateral appointment is bad. The same is also decided in core cases, core 1, 2, 3, where they said unilateral appointments is not allowed in arbitration. Both the parties have to give consent. Now, these are cases which I jotted down because these have something which lay down a new phase within the Indian arbitration. The second one on the slide is also very important, Vijay Karya, in which every time when a foreign arbitral award used to come to India for enforcement, every time the party was almost challenging it based on some or the other ground, for example, public policy. In Vijay Karya, the Supreme Court said that the grounds of resistance under Section 48 is very limited. So we are not going to use public policy exception as a very wide clause. We have to make it very narrow. Why? Because Article 5 of New York Convention provides for a pro-enforcement wedge to the foreign arbitral awards. So India actually took a very good step coming up with a pro-enforcement approach. Any questions so far? Okay. Now, if we look at the Indian centers, so we have some Indian centers, for example, Mumbai Center for International Arbitration, India International Arbitration Center, Delhi International Arbitration Center, IMC Hyderabad. Now, one of the regulators which came up in 2019 in the amendment is Arbitration Council of India. Their job is to promote institutional arbitration, grade arbitral institutions, recognize professional institutes for accreditation and training. However, as we talk now, the ACI is not functional, it's not constituted. Now, just to give you an idea that how institutional arbitrations take place in India. So one of the reports is this MCIA Annual Report 2025, which provides that the cases which they handle is 61. Total cases since inception is 181, international matters 81%, women arbitrators appointed is 38%, which is a very good initiative that has to be appreciated. So this is the figure with MCIA. If we look at DIAC, Delhi International Arbitration Center, this is a court annexed arbitration center. MCIA is not a court annexed center, it's a full-fledged private arbitration center. DIAC is a court annexed arbitration center of Delhi High Court. So in this one, if we look at the total cases, it's 12,115, which is huge. Of course, it is also a lot of cases because it's court annexed, but it has a good amount of caseload. Now, how many cases disposed? It's 1477. That wraps the discussion on the Indian jurisdiction. Now, let's move from Indian jurisdiction to do a comparative study of the other jurisdictions and how they perceive international arbitration. Now, in Singapore, the law is International Arbitration Act 1994. This is again an adoption of UNCITRAL model law. Of course, there are certain modifications to it. They have also adopted the New York Convention. I'm not going to cover the sections because it's already there on the slide and you also have the slide. So let's skip to the main landmark judgments. The first one, the Silica investors, the court stayed the court proceedings in favor of arbitration under Section 6 of IAA and held that minority shareholder claims are arbitrable. It applied a prima facie test to determine the existence and scope of the arbitration agreement. This is one of the judgments where they actually said that minority shareholder claims are arbitrable. This showcases how expansive their interpretation, how liberal their interpretation, while deciding their definition or deciding what constitutes valid arbitration agreement. If that would have been a case in some other jurisdiction, it would have been decided that this is non-arbitrable. But the court said it is arbitrable and you can go ahead with the arbitration. The second one is actually Anupam Mittal, who's the founder of Shadi.com, also one of the sharks from the Shark Tank. So this is exactly a case arising out of their dispute. So it's Anupam Mittal versus Westbridge, in which the whole idea was whether the subject matter of the dispute is arbitrable or not. And the court came up with a composite approach to decide arbitrability. And the court said to decide what is arbitrable, there are two stages. First, that it has to be arbitrable under law governing the arbitration agreement. Second, that it has to also pass the test of the seat. And if either law considers it non-arbitrable, then arbitration cannot proceed due to public policy. Now, this is a very Singapore specific test, which is very famous. It's called composite approach. It's very a recent judgment 2023. Then in China machine, there is another case, which is in which the court refused to set aside the arbitral award because of minor procedural irregularities. There was a challenge to set aside the award. The court said, just because of a minor procedural irregularity, we are not going to set aside the award because we follow a pro arbitration approach. We are not going to set aside the award. Now, if we look at the Singapore Arbitration Institution, the leading one is Singapore International Arbitration Center within the Indian jurisdiction. Also, they are very famous. Some days back, there is this new office of SIAC, which has been opened in New Delhi. And this has a lot of Indian parties as well. Now, let's look at how this SEAC report talks about the number of cases they have. So in this 2025 year, they had 886 cases. International cases constitute almost 90%. Total sum in dispute USD 14 billion. Party jurisdiction, it covers countries from 79 jurisdictions. If you look at the top foreign user, China has 378, Vietnam has 337, India has 178 cases. So now you can understand how much arbitrations from the Indian parties is flowing into the Singaporean market. If you look at towards the end, emergency arbitrator applications 19. So they also have a lot of emergency arbitration, and within the Asian setup, it has one of the largest emergency arbitration cases. If we go to the West, it's more in the American Arbitration Association, ICDR, and then the ICC. Any questions so far on India and Singapore? Okay, now let's go to UK, where we specifically talk about. Just give me a second. So sorry. So if we look at the UK legal framework, this is based within the international commercial. This is applicable to the ICA seated in England and Wales, and this is governed by the Arbitration Act 1996. Now, if you look at these sections, it's pretty much relatable to it's pretty much similar to the Indian Act also, because it comes towards the same time, and we also use ancestral model law. UK did not adopt ancestral model law, but if you look at the primarily the sections, it's pretty much around the same numbers. However, there are some different things which you should focus on. One is section 67, 68, 69. 67 provides for challenge to substantive jurisdiction. 68 provide for serious irregularity, and section 69 is very different than the Indian challenge. It provides for an appeal on question of law. They do not use the term challenge. So it's very wider, but they provide this within the Act. Now, one of the major developments which they came up with is the Arbitration Act 2025. Now, this Arbitration Act 2025 does not repeal the Arbitration Act of 1996. It's an amending act which does a major amendment with respect to Arbitration Act 1996, which came on 24th Feb 2025. It got the royal assent and came into force. Now, one of the important things of this was they provided a provision, I think it's section 6A, which provides that if the parties do not choose a law governing arbitration agreement, by default, it's going to be the seat law. In this case, it's going to be English law. Then codification of the arbitrator's duty of disclosure is also there. Summary disposal power is included in this, and also changes concerning jurisdictional challenge. So if you are reading on UK international arbitration, you have to make sure that you also study the recent 2025 Arbitration Act. You cannot just read 1996 because that's the old interpretation. A lot of things have been, changed after this new amending act, Arbitration Act 2025 came into picture. Now, if you look at the landmark judgments, starting from Fiona Trust, in Fiona Trust, they actually said that the intention of the parties play a very wide role, and commercial parties intend to resolve all their disputes through arbitration. They do not think that some of the disputes should go to arbitration, some of the disputes go to litigation. When they write an arbitration agreement in the contract, it means all of the dispute or even connected to it should go to arbitration. So this talks about the commercial parties' intent to arbitrate. Now, in another case, Dalla versus Pakistan, court held that it can independently determine whether a party is bound by the arbitration agreement when deciding enforcement. In another case, Halliburton versus Chub, court recognized an arbitrator's duty to disclose circumstances that may create justifiable doubts about impartiality. Enka versus Chubb is another landmark judgment which comes on the issue of law governing arbitration agreement, and court address this issue, distinguish it from the law governing the underlying contract. They actually did some modifications into the case of Sula America, where they say that more closest and most connection test is something which we have to follow. Now, if we look at the UK arbitration institutions, the landmark institution, the leading one is London Court of International Arbitration. One of their important feature is that they do not charge the fees, as in the arbitrator's fee, based on the total claim amount. That out, let's say if the claim amount is 100, so they charge 5% or 10% for this. If it goes beyond 10 CR or 100 CR, then it's 5% plus 5% additional if it goes beyond 100. They don't charge like that. How they charge is more like hourly rates instead of deciding based on amount in dispute or the claim amount. Now, if we look at the recent annual casework report of LCIA, the total referrals to LCIA is 360. LCIA rule arbitrations 318. If we look at the international cases percentage, it's 95%, which is also more than the 89% of CAT. So you can understand how international LCIA is. The top sector in this is transport and commodities, 29%. If you look at the expedited or emergency arbitration, it's almost the same numbers like Singapore International Arbitration Center. Now we have covered India, we have covered Singapore, we have covered UK. Now we are left with two, France and US. Any questions so far? Okay, now let's start with our discussion on the French arbitration legal framework. Within the French system, we do not have special laws. What we have is Code of Civil Procedure, in which you have different chapters. Now, one of those chapters is on arbitration, which is called Book 4, Title 2. Now, within that, it's all about arbitration. So, starting from Article 1504, it goes till almost around 1527. So, there are certain important provisions which are there on the slide. One of the important feature of this is 1505, which is French court's role as supporting judge, which means they are not going to decide the dispute. All they are going to do is help complement arbitration. They're not going to decide anything. It's just a supporting judge role which they have to play. Now, if we look at the Article 1525 to 1527, they have removed this ground for refusal of enforcement of foreign arbitral award based on this ground, which is if the award is set aside in another jurisdiction, which is usually there in New York Convention, which is also there in a lot of countries which has followed NYC. So they have removed that within the French law. So even if the award is set aside, you cannot come to the French courts and say that you should not enforce it because that's in NYC and that's there in your national law, because the national law has actually removed that ground. Now, if we look at the French landmark judgments, first one is Dalico, in which the courts recognize the autonomy of international arbitration agreements from national contract law. Second is Hill-Martin, where the courts recognize the international character of an award independent of the seat, where they said that, of course, it is anchored to a seat, but it doesn't mean that an arbitration is rooted within that national jurisdiction or a national judiciary. It has an independent nature, which is international character. Then, in another case, Putra Bali, they reinforce the autonomous and delocalized nature of international arbitration and France pro enforcement approach, which basically, in this case, what happened that the award was set aside at the seat. And when it went for enforcement in French courts, one of the parties was saying that the award is already set aside at the seat, so technically doesn't have the force of law. The French court said that it's an autonomous and delocalized nature of the arbitration award, and we will look into it. If we find the award fine, we will go ahead with the enforcement. And in this case, actually, they went ahead with full enforcement, and that is also called the French pro-enforcement approach towards enforcement of foreign arbitral award. In another case, Kababji, They applied French substantive arbitration rules to determine the validity of the arbitration agreement where the parties had not clearly chosen another law. And majority of the French cases, they use transnational principles while deciding the issues on law governing arbitration agreement. Now, the one of the most famous international arbitration center is International Chamber of Commerce, their Court of Arbitration, which is in short called ICC. Their recent report, dispute resolution statistics show the number of cases filed is 881, total number of parties almost 2,500. 147 party jurisdictions are there, which means 147 countries out of the whole world, which means almost three-fourths of the world is having an arbitration with ICC. And if you look at the total pending caseload value, it's 300 USD billion. Now, if you look at the place of arbitration, which means seat of arbitration, it's 123 cities. And in terms of countries, it's 70. You can understand how big this institution is. They also do arbitrations seated in India in multiple cities, actually, not even one city. They go beyond Delhi and Mumbai. Awards approved, they also do scrutiny of awards. So awards approved is 607, expedited procedures 169, emergency arbitration 30. If you look at the number of women arbitrators, almost reaching 50%, which is 44.6. The top sector in ICC is 28% construction and engineering. Now let's move towards the last part of our discussion, which is United States. The law with respect to international arbitration is Federal Arbitration Act. And please understand that US is a bit different. US has a federal arbitration law. US also has a state arbitration law. For example, in India, in Haryana, there is no Haryana Arbitration Act, right? Or let's say if you go to Bihar, you don't have a Bihar Arbitration Act. It's just one national arbitration law, which is Arbitration and Conciliation Act 1996. However, if you go to US has a different style of federalism in which you can have a federal arbitration law, you can also have a state arbitration law. Here we are discussing with respect to federal arbitration law, which is Federal Arbitration Act. Now, in this, the Federal Arbitration Act is something which is different and does not have one comprehensive arbitration code, but the main legislation is Federal Arbitration Act, which is more coming from 1925. It's very old. In France also, I think it comes from 1981, the book 4. However, and of course, they had a lot of amendments afterwards, but their primary law comes from 1925. I think the French one is 1981. And then there are certain sections which I have already put up on the slide. And New York Convention is, of course, a part of this, which is section 201 to 208. One of the different thing in this is section 11 clearly provides for modification or correction of awards. It's not just correction, they also provide for modification. And a lot of times in US, it's called vacating the award instead of setting aside, challenge, annulment. But all of these nomenclature means the same. If we look at some of the judgments, Mitsubishi in 1985, the Supreme Court upheld the international arbitration of statutory claims, reinforcing the strong federal policy favoring arbitration. In the second case, the courts decide arbitrability unless there is clear and unmistakable evidence that the parties delegated the question to arbitrators. Hall Street Associates, which is FA Section 10 and 11, provide the statutory grounds for judicial review. BG Group, in which arbitrators may decide procedural conditions to arbitration where they do not determine the parties' underlying consent to arbitrate. And the last one is where the court upheld arbitration agreements with class and collective action waivers, reinforcing federal support for arbitration. Now, within the American jurisdiction, the arbitral institution, the most active one is AAA, which is American Arbitration Association, and they have different wings. One of their arbitration wing is called the International Center for Dispute Resolution. Now, in this one, if you look at the number of cases which they have, international arbitration is 725. The international mediations, they have 73. The total amount claim is almost around 5 to 6 billion. The number of jurisdictions which they are covering is 96. Their largest claim is 514 million. If you look at the number of cases from their inception in 96, it's 22,000. So this is what I had to discuss, and with this we come towards the end. If you have any questions, we open the floor for questions.
So participants, the floor is open for the questioning. If anybody have any question, can ask. So anyone?
Uh, Good evening, sir.
Hey.
So, sir, as you have mentioned that in London there is this Section 69 which allows appeal on question of law.
Hmm.
Of course, until unless parties opt out. But in Singapore and in Paris, it operates, I think, on a strict opt-in or total prohibition basis. I was not able to understand the terms. What does it mean by that? But I'm guessing total prohibition means that you cannot appeal it on question of law. Like you don't have any special provision like London has on Section 69. So does London's approach make it more attractive for legal certainty, or does it undermine the core principle of this finality? That is also a major issue in India because we have this issue like parties tend to use the loopholes so that arbiter award can never get that finality. So how do you at all this issue overall?
I'll say if you look at it from the perspective of a pro arbitration approach, giving powers for an appeal is going to be very wide in nature. Of course, it is working out for London because London has a very old jurisprudence on arbitration. But for a country like India or for a developing arbitral jurisprudence country, it's going to be very debatable. And if you look at some of the jurisdictions like Singapore, they do not provide for modification or they do not provide for appeals because they say whatever you decide as an arbitral tribunal, that's going to be final and binding unless until there is an issue of a very serious procedural irregularity. And this is not only Singapore is following. This is something which is also the French approach. So, like, of course, any country has to make a decision that which approach is something that is going to be attractive for them. But of course, one side for argument is that in certain cases where there is a very grave mistake of interpretation of law by the arbitrators, then there needs to be a power of using these appeal powers under the Arbitration Act so that the courts can relook into it. So there are arguments for both the sides, but I will say it's you have to also look at it from the perspective of pro arbitration approach. Yeah.
Answer, do you think, like, especially in India, in previous session as well, there has been this discussion that India, like, it wants to, like, we keep on saying that arbitration is growing in this country, but there's this practice among advocates and, parties that they never want to achieve that finality. So what do you think about this whole scenario? What should be the right way to approach this?
I would say that there needs to be a full stop to this discussion on the enforceability. Now,
Hmm.
once an arbitral award comes in, it has to be given effect. Of course, there are powers under Section 34 to look at the setting aside. But the problem is not that having a provision like Section 34, that comes from ancestral model law. Singapore also has the same law. France also has the same law. The problem is not having a provision for setting aside. The problem is how are we actually, you know, deciding those cases. So I was reading one of the interviews where one of the retired Supreme Court judge said that one of the problem with Section 34 application is that a judge has so many cases to look into that Section 34 dates, even the first hearing doesn't come very soon. Then it takes a lot of time to dispose of this Section 34. And what if I tell you that this Section 34 does not go directly to the Supreme Court? It depends on the amount in dispute. It depends on whether it is international commercial arbitration. So it may be a chance that it starts at a local court, then it goes to high court, under Section 37, then it goes another Section 37 in Supreme Court. I think this is what you are referring to, and this is something which constitutes a lot of delay. And these needs to be sorted. And all of this is already, sorted out in jurisdictions like Singapore. So it's not something that has not been solved in the other jurisdictions. All we have to do, I'm not saying that we have to copy any jurisdiction, but we have to improvise looking at what people have been doing in this. If Section 34 gets decided within a very strict timeline, then where is the issue of finality? So that's something which we have to look at, because if we remove Section 34, that is not the solution. I will say the gap is in terms of implementation. The law is fine. Yeah.
Thank you, sir.
And also, I have shared my contact details right here, the scanner. If you have any questions which we can't discuss here, you can always write to me. The slides link I have already shared. Any other question, guys?
Kumar, Suman, if you have any question, you can write it down in the message box.
Am I audible now?
Yes.
Yes.
Yeah.
Sir, I have in this, as far as Section 34 is concerned, my perspective on this, and you would guide me on this, that since challenge of an arbitration award is a legal right, under Section 34, though it is very limited on limited grounds. But what the approach is should be rather, that there must not be a stay on the execution of the award, where the problem comes. That supposedly, if I got an award of rupees 10 crore, and then
I understand your question. So you are saying that there is an automatic stay on the award?
no, sir, in most of the cases in arbitration, there is no mandatory deposition of the arbitral amount is to be deposited in under Section 34.
I got your question.
That is the question of, a debatable question, that it should be mandatory or voluntarily. So sometimes what happens is that people challenge the award under Section 34 and the court grants the stay on the execution of the award. And it keeps on going for years and years. That's the main issue. We cannot solve this, the petition under Section 34 because of influx of cases, number of cases in a very short span of time. But what we can do for for a decree holder, that he should be given his dues within a time frame. The amount which he's supposed to get under the award.
I think your comment is on point. It's pretty much related to what Yash was also talking about, that how delay is also linked to different things. One of the potential solution is what you are saying. It's being done in some high courts. Two of the examples are Bombay and Delhi high courts, but not all the cases. There is no national law or guideline which says that you have to deposit the full amount or some percentage, but a lot of courts on their own initiative, they're doing it. But if you look at some of the Indian high courts, majority of it are not doing it. So technically what people do, people file this Section 34 as a delay tactic. So you are right in saying this. And the legislature hasn't taken this into consideration. And as far as I know, the bill 2024, which is still pending as a bill, does not talk about this, does not do anything on this front. So what you are saying is actually a good idea. But as we talk now, this is not even in the pipeline. But you are right that this will help at least solve some portions of Section 34 delays.
Yes, sir.
Any other question, guys?
Any participant have any question? So I'm going to take this as there's no question. So, sir, may we proceed for the conclusion?
Yes.
Thank you, sir. As we conclude today's capstone session, Comparative Study of International Arbitration Law, I would like to express my sincere gratitude to Professor Dr. Akash Gupta ji for sharing his invaluable knowledge, extensive experience, and global perspective with us. We are truly grateful for your time, generosity, and for sharing your expertise with us today, sir. I would also like to extend my heartfelt thanks to our participant for joining us this evening and for your participation. We hope today's session has been both inspiring and informative. Thank you once again, everyone, for being with us today. Have a wonderful evening. Thank you, sir.
Very
Thank you.
much.
Thank you,
Bye-bye.
sir. Thank you so much, sir.
And participant have any query they want to ask, they can connect with the sir on Instagram or the links sir shared with you all. Okay. Thank you, sir. Thank you so much.
Thank you.
Have a great evening.